expressed on the following sponsored program are strictly those of the host, guests, and callers, and not necessarily those of this station, its staff, management, or sponsors. Welcome to the South Florida Family Law Show with attorney Sean Shepard. Sit back today as attorney Shepard shares his vast family law experience. Attorney Shepard has 18 years in the area of family law. He has handled thousands of cases and hundreds of contested trials before both judge and jury. He is here every week to educate you on your rights and to answer your questions pertaining to family law. If you have a question regarding family law, call attorney Sean Shepard toll free at 888-565-1470. And now, here's attorney Sean Shepard.
Hello, happy Friday to everybody. It's another week of South Florida Family Law Hour. My name is Sean Shepard. I'm an attorney. I've been an attorney for 18 years. If you're new to the show, welcome. If you're returning to the show, welcome back. And as always, we invite you to call in, invite you to watch the videos. It's streaming on wwnnradio.com. Call in with any questions you might want answered. If you're tuning into the show and you may have somebody who's interested in listening right now, give them a call, tell them to tune into the show. We're talking this hour, as we do every Friday at 5 o'clock, about family law issues here in South Florida. Any questions you have regarding family law, call in, give us a call. We're happy to answer your questions regardless of what we're talking about. Today we're going to be talking about uncontested divorces, the procedures for getting uncontested divorces processed. And if we have time, we'll move into areas of modification when you've already been divorced, and contempt and enforcement issues as well. But as always, we invite you to call in with questions, even if they're not in the area we're talking about, and we'll certainly sidetrack the conversation and answer your questions as best we can. Questions are free, answers are free, and we encourage you to call in. For those of you out there who are in a situation where you've been separated for quite a long time, or have worked out some amicable resolution with your spouse, and want to proceed forward with an uncontested divorce, the process is simple, relatively speaking, in the area of family law, but complicated to a lot of people who don't understand it and aren't familiar with the court process. It sounds very inviting, an uncontested divorce, and it seems like it'd be a simple thing to do, and it should be a simple thing to do, but unfortunately it's not. Despite the fact that it would be uncontested, you still have to go through the same procedures as a contested proceeding as far as filing is concerned, and as far as following through with the paperwork that needs to be filed. And despite the fact that everybody involved in a divorce situation wants to get it over as quickly as possible, and as inviting as the word uncontested is, more times than not, people involved in uncontested situations are open themselves up to having things happen in the future that were not anticipated. So if you're thinking about an uncontested divorce, or have a situation where you're really close to an uncontested divorce situation, tune in. We'll talk about the process going through an uncontested divorce. If you're listening to the show for the past several weeks, we spoke several weeks back about the nuts and bolts of filing for divorce here in Florida. For an uncontested divorce, the first thing I ask people who come in and say that they have an uncontested divorce, first thing I do is confirm that they actually do. A lot of people think they have an uncontested matter, and when I ask them, well, have you talked about this, or you've talked about that, a lot of issues have just been ignored or swept under the rug because they don't want to create conflicts or create a contested situation. Unfortunately, you get one shot at the divorce process, and all the issues in your matter have to be uncontested in order to have a quote-unquote uncontested divorce. So the first thing you need to realize is that there are a lot of issues out there that you need to address in order to qualify to have an uncontested divorce. Of course, when you have minor children involved, or you have a marriage that's been a lengthy marriage, the longer the marriage and the fact that there are children involved create issues that have to be dealt with in a certain way according to Florida law, and it creates bumps in the road that sometimes make it harder to get an uncontested divorce than others. Some of the things you need to think about when you're seeking uncontested divorce is you need to outline all the issues that you need to discuss with your spouse to make sure that in fact you do have an uncontested situation. If you have children involved, you have to make sure that you've come up with a parenting plan. In Florida, they've developed a situation where you have to have a parenting plan in order to get divorced if you have minor children to the marriage. A parenting plan is a form document. You can get them online. You can go to the clerk's office and get one. Clerk will charge you money for those, so I encourage you to go online and print those off. It's cheaper that way. These packages are available online to print off online. The forms are identical to the ones that the court would provide to you at a charge. So go online and print off the documents you need. With children involved, you're going to have in your consent final judgment discussion regarding child support and the parenting plan. These are necessities. A judge will not allow you to get divorced with children if you fail to address all the child issues in your case. In filing for an uncontested divorce, the way that I handle those in my office is I charge a flat fee for an uncontested divorce. In Florida, the filing fee for divorce typically will run you, including your issuance of your summons, about $411. And in any attorneys who handle uncontested divorces will quote you a flat fee, inclusive of what the filing fees are. So you have $411 that's going to the clerk in order to file your case and issue your summons. And then you also have, if it's a contested matter, you're going to have to pay for a service fee to have a process server serve your spouse. In an uncontested case, you avoid having to pay that fee. That fee is typically $40 to $60 locally to have somebody served with a summons and a petition. But proceeding on the uncontested divorce case, you're looking at about $411 in costs. And the way I would charge out a case for an uncontested divorce is I charge $1,000 for the fee for preparing all the documentation and the $411 for the filing fee. So the total fee paid for an uncontested divorce is $1,411. Different attorneys charge different amounts for uncontested divorces. You'll see people out there who advertise that charge $299 or $399 to do an uncontested divorce. Certainly doesn't include the filing fee, and you're probably getting a paralegal or somebody who's not a qualified attorney to prepare your paperwork for you. In a situation where you have a truly uncontested divorce, no children issues, no asset issues, and there's nothing to fight about at all. There's no division of debt, no division of assets, married for a short period of time. That's the simplest of issues to deal with. You still have to go through the process of filing a petition for dissolution of marriage, and it's still the same process to go through as somebody who has more complicated issues to resolve in an uncontested divorce. When you file for an uncontested divorce, you still do the same thing as you do for a contested divorce. You file a petition for dissolution of marriage. Your other spouse files an answer in response to that, admitting the allegations in the petition. You'd also have the other spouse file a waiver of appearance at the final hearing. And as is in every divorce case in the state of Florida, both parties have to file financial affidavits with the court. There's no ability to waive that, even if you've agreed upon everything. It's a statutory requirement that both parties file financial affidavits, and those need to be completed and filed with the court before you can actually get a divorce decree. In addition to that, if you have children involved, even in an uncontested divorce setting, you have to file with the court, whether you include it in your petition or do it as a separate document. There is a uniform child custody jurisdiction enforcement affidavit needs to be filed. That states the names and dates of birth of the children and indicates to the court that where they've resided for the last 5 years, and also indicates whether there's been any previous proceedings involving these children in any other court or jurisdiction. The purpose of that is to put the court on notice if there's any other court proceedings that were had in any other jurisdiction or court, so that they're aware of any related cases. Other than that, in an uncontested divorce, the last document you're going to have is going to be what's called your consent final judgment. This is the main document you want to make sure is accurate, make sure that it reflects the entirety of your agreement with your spouse, make sure there's nothing left out, and make sure that you have an attorney review that document. That's, for lack of a better term, your contract with your ex-spouse. That is the enforceable document that you have. That's your agreement with your former spouse on all your issues. Like I said before, if you have a situation where you have children involved, not only are you going to have a consent final judgment of dissolution of marriage, you're going to have, in addition to that, a parenting plan. And that parenting plan is going to be incorporated into your consent final judgment. What you need to do with an uncontested divorce situation is everything you need to include in the consent final judgment needs to be included in there, and that includes child support, alimony if there's going to be alimony exchange, division of assets if you're going to divide up assets, division of accounts, division of debts. If there's real estate involved, you have to explain in the consent final judgment how you're handling the real estate. You have to explain in the consent final judgment how you're handling tax filings for that year and years to come. You have to include in the consent final judgment with regard to minor children who's going to be claiming the minor children for tax purposes, and anything that you want to have addressed with regard to your relationship with your spouse needs to be included in that document. If, for instance, you enter into an agreement, you print out a form online of a consent final judgment, and you sit down with your spouse and you check a few boxes and you indicate on there things that you want to include in your agreement, and there's boxes that are not checked and there's blanks that are on there that you don't fill out. All the judge is going to ask you if you walk in pro se is that whether or not you both agree to this. And if you both agree to it and the judge enters it, that's going to be written in stone. And you may be waiving rights that you don't understand you're waiving. You may be creating issues that are going to create problems for you years down the road. And I definitely encourage you, even if you're going through the process of an uncontested divorce and filing your own paperwork, filing your own petition and your answer, that if you come up with a consent final judgment and you agree to terms with your spouse, that you have that document reviewed by an attorney. There are attorneys out there, including myself, who will review that document and give you advice on whether to include certain things, change certain things, at a fee, of course, depending upon the amount of time it takes to review the document. Well worth the money to have an attorney review that, particularly if you're saving money on filing the rest of the documentation yourself, because that document is crucial to the rest of your life. Like I said before, you may be inadvertently and you may be unknowingly signing a piece of paper that creates obligations for you down the road or waives rights that you have that you aren't even aware of down the road. And despite the fact that you want to get through this and want to go through an uncontested divorce, don't want to drag it out, don't want to have the emotions involved in a contested proceeding, definitely seek the advice of an attorney to review the document for you and make sure that you're doing it the right way. Oftentimes both parties agree on things and both have the same intent of doing something, but they enter into a consent final judgment that states otherwise. It states things that they didn't really agree to. And I've seen situations where people come to court years down the road where they were in agreement originally and the document said something inconsistent with what they agreed to, and circumstances changed and one spouse takes advantage of the fact that a document was drafted poorly and they are given rights that they otherwise didn't know they had. So definitely worthwhile to have an attorney review the process. For the fee involved being an uncontested flat fee divorce, it's certainly worth the investment. You can split the cost of an uncontested divorce between two parties that agree. A lot of people ask me that they'd come in together and say, Sean, can you represent both of us in an uncontested divorce? And the answer to that is very simply is no. The Florida Bar doesn't allow an attorney to represent two people on two different sides of a lawsuit, and this is a lawsuit. So what would happen in this process is that I, as the attorney preparing the documents, can prepare the entirety of the documents. I can have a meeting with both parties, but I only represent one party to the transaction. And I clearly state to the other party, I don't represent you. You're welcome to get an attorney of your own selection, but I cannot give you advice. I can explain to the other party what the documents mean, what the documents say, but the thing that I can't do is give advice to both sides of that transaction. What it does, and obviously both parties can split the fee financially, the documents can all be prepared by one attorney, but both parties cannot get advice from the same attorney. It's just an ethical obligation that we have as attorneys, and the bar does not allow us to do that. And it wouldn't be right to give advice to two different sides of a transaction. So if you want to proceed with an uncontested divorce, the best advice I could give you is sit down with your spouse, come up with as complete an outline to your agreement as you can. If you haven't calculated things like child support, that's something that an attorney can do for you. It's become somewhat complicated in calculating child support, but online they do have some tools available to pro se litigants. If you go on to any one of the search engines and type in Florida Child Support Calculator, you can get any one of several different calculative tools that allow you to input information regarding you and your spouse, input information regarding how much money you each make, how much child support is paid from other relationships, how much health insurance is paid for the participants and the minor children, how much daycare is paid for the children from each side, and you can simply click a calculate button and it'll spit out a child support number that's usually pretty close to what the court would order you to pay. If you enter into a consent final judgment and you've calculated child support, one of the things you need to realize are these calculations include now calculations of how much time each parent is going to spend with the children for overnight purposes. So a lot of people have relationships with where one spouse travels a lot. You may have somebody who's a truck driver or somebody who's in the military, and the overnights may be in one situation, 300 overnights to one party and 65 overnights to another. And you may have other situations where the parties have agreed to equally split the time sharing with the children. These decisions and time sharing drastically affect the amount of child support that's paid one to the other. The computer programs have developed very fairly to allow the calculation to include consideration of whether or not one spouse is going to have the children for more overnights during the year than the other, and it automatically calculates into the child support a consideration for that factor. We'll talk in a little while about how that impacts modifications if you have a situation where you've agreed upon a split custody arrangement where you're each sharing overnights with children, and then subsequent to the divorce you end up having a situation where one spouse is not holding up to their end of the bargain as far as visitation. I'll talk about that in a few moments about how you can seek a modification for that. But come up with a consent final judgment outline. Definitely consult with an attorney if you have the means to do so. The process is a lot easier to get through if you have an attorney involved, and a lot quicker to get through if you have an attorney involved. A lot of people get into filing for an uncontested divorce and come to me halfway through the process just not understanding the administrative components of filing and filing the requisite documents and actually scheduling a final hearing to appear before a judge. And they just get fed up with the whole complexity of the whole thing and come in and hire me to finish it up for them. It's complicated to people who don't understand it. The clerk's office is helpful to a degree, but not helpful entirely. And the scheduling process is overcomplicated. So if you have the means, hire an attorney to do it. It'll get done much more quickly, and you'll have the benefit of having the advice of a seasoned attorney to represent you on all those issues. what you do need to be aware of is that you do need to, one of you needs to attend a court proceeding in order to get divorced. Despite the fact that it's uncontested, one of you needs to appear before a judge at a hearing, raise your right hand, get sworn in, and answer a number of questions in order to allow the divorce to go through. Likewise, even if you have an uncontested divorce situation, one of the parties needs to meet the criteria for being a resident of the state of Florida. So if you've just recently moved to the state of Florida and haven't lived here, one of you haven't lived here for at least 6 months prior to filing the petition, even though it's an uncontested case, the court is not going to allow you to get divorced until you reach that one of you reaches the 6-month mark for residency purposes. So keep that in mind for those of you who moved to Florida recently and want to file for divorce. Again, even if you have an uncontested divorce proceeding, there are positive divorce resolution courses that parents need to take, and even if it's uncontested, you need to take those as well, just as if it were a contested case. Courts will not allow you to get divorced without taking the requisite course. The course provides information to divorcing parents on how to deal with minor children. Of course, if you don't have children involved in a divorce, you don't have to take that course. But if you do, you have to complete that course and actually file with a court a document that says that you've satisfactorily completed it before the court will enter a final judgment in your case. So keep that in mind as well. It's one of the things that people forget if they're not represented by an attorney, forget to do, or think that they can sneak under the radar and not have to do it. But judges will check every aspect of the file to make sure that everything's been done in your case before they enter a final judgment of divorce in your favor. A few things I wanted to talk about with regard to uncontested divorces. If you have real estate or if you have insurances in place, particularly health insurance, a lot of people these days stay together even though they're separated for a long period of time. There are triggering events, and a divorce is one of those. And what a divorce does to your health insurance in particular is in most cases it terminates your health insurance as a spouse on a policy. It may take a few weeks for that to happen, and depending upon the length of your marriage, and even in situations where you haven't been married for a long time, as an ex-spouse of somebody, you may be entitled what are called COBRA benefits. COBRA benefits are health insurance benefits that are afforded to spouses to allow them a bridge to being able to acquire insurance of their own. Typically, COBRA benefits extend to a maximum of 18 months. And again, you should check with the provider for the insurance or the employer for your spouse to see how a divorce will impact your entitlement to insurance. Of course, if there's minor children involved, the fact that there's a divorce involved in the proceedings will not affect the minor children's entitlement to health insurance, but you as an ex-spouse will have some effects on you from a divorce. So I'd certainly encourage you before you file, particularly if you're suffering from some type of significant illness or problems that you're seeing doctors about, find out what's going to happen to you in the event of a divorce so you can plan appropriately to have either substitute insurance put in place or to seek the COBRA benefits to which you're entitled to. COBRA benefits could be expensive. It's one of the questions you should ask as well in planning to go through a divorce process, to find out what the costs of those are so that you can come to some agreement with your spouse as to how those will be paid. A lot of people go through the divorce process, don't realize the cost impact that COBRA coverage will have on them, and don't factor that into their agreement with their ex-spouse and are left out in the cold in that regard. So these are things you need to plan for and things you need to cover when you enter into an agreement for an uncontested divorce. Also, if you own real estate together as husband and wife, when you're married, by default or by plan, if you own real estate with your spouse, it's titled as joint tenants with rights of survivorship. When you get divorced from a spouse, if you decide to keep property in both your names, that joint tenants with rights to survivorship, if it's not expressly stated in the document in the deed, if it's just husband and wife, doesn't state joint tenants with rights to survivorship, and it doesn't state husband and wife, perhaps you acquired the property before you got married in both names, a divorce will make that joint tenants with rights to survivorship, as a matter of law, convert into a tenants in common ownership. And if you have any deaths out there, if you have any situations where someone has a judgment against one or the other of you, the loss of that joint tenants with rights to survivorship designation could impact you and could subject you to having a collection or lien against your interest in the property as a 50% owner. So those are things you want to consult with an attorney about as well. If it's your homestead property, there are other protections that are in place because it's homestead, but there are some complicated issues involved, particularly when you own real estate together and other issues, and these are all the more reasons why you should consult with an attorney before doing this. We're going to move, after we take a short break, we're going to move into areas of modification. We'll finish up what we talked about last week when we were talking about appeals. We'll move into modifications of existing orders, and we'll move into some contempt and enforcement actions when things aren't done the ways that they were ordered to be done. So we'll be right back after the break.
Attorney Sean Shepard has been practicing family law for 18 years, and he is in good standing with the Florida Bar Association. Attorney Shepard is licensed to Florida, New York, and New Jersey. He is a trial attorney with his primary practice in the area of family law litigation. He has handled thousands of cases and hundreds of contested trials before both judge and jury. Attorney Shepard is a former judge, advocate, general court officer from the United States Navy, and therefore possesses a wealth of knowledge regarding military-specific issues to divorce and other family matters. Attorney Shepard not only handles matters from intake through trial, but he also handles all matters of post-trial and appellate work. His unique background has enabled him to develop a keen insight into all aspects of family law litigation, from beginning to end. If you or a family member are about to go through a divorce or have other pending family law problems, contact attorney Sean Shepard today at 954-632-0668. Let attorney Shepard give you sound advice and fight for your rights. Offices in Fort Lauderdale. Call him today to make an appointment. 954-632-0668. You are listening to the South Florida Family Law Show with attorney Sean Shepard, bringing you all the answers to the questions you have about family law. Join the conversation at 888-565-1470. Now, back to our show.
Welcome back. If you tuned in last week, we spoke at length about appeals and the structure to appeals, how you go about appealing a decision where you feel you've been wronged by a judge in a divorce proceeding or a paternity proceeding. And I want to talk a little while today about another form of relief from judgments that are entered against you that you may not agree with. And I want to also talk about enforcement actions. I have situations come up on a daily basis with regard to enforcement. People are frustrated that they have an order that was entered in their favor. It may have been years and years ago. It may be a divorce decree that's from 15 years ago. It may be one as recent as a month ago. In either event, you have a right to seek enforcement of a final judgment or other order of a family court. A lot of people ask me, where do they bring this enforcement action? Where do they have to bring it? The court who entered the final judgment of divorce or other order is the same court where you should file the enforcement action, regardless of where you or the other party to the action reside now. So to the extent you have a divorce decree or an order of any kind from a family court here in Broward County, Miami-Dade, or Palm Beach County, you should file what's called a motion for enforcement. We spoke several weeks back about contempt proceedings, and when contempt proceedings are available to you. Typically, contempt proceedings and the remedy of contempt, being able to incarcerate somebody for doing something wrong, for civil contempt, apply only to support issues, child support, alimony, or other financial obligations that are imposed upon one party in favor of another. But there's another vehicle even when you don't have contempt available to you, and it's called a motion for enforcement. A motion for enforcement is a very simple document. It's a motion to the court saying, on such and such date, this court entered a final judgment or an order, that final judgment or order required the other party to do X, and that the other party has not done what they've been ordered to do. And you're seeking enforcement of that court order. And the way that you seek enforcement of that court order, there's a number of different ways to do that. In all of these cases where you're seeking enforcement, part of what you're filing with the court should always be, if you're represented by an attorney, a request that your attorney's fees and costs be paid. If you're not represented by an attorney, you should request that your costs for filing the motion be reimbursed to you. But I definitely encourage you, if you have a situation where you're filing a motion for enforcement, that you hire an attorney to do that. You can always seek, as part of your motion for enforcement, an award of attorney's fees and costs, so you can get those reimbursed from the other side, particularly when you prevail with the action. Courts are very inclined to award attorney's fees and costs so that you're put in a position where you're made whole from the process and you're not required to go out of pocket to file and pay an attorney to file something that is the entire fault of the other party. So a typical situation, you may have an order, and this happens a lot, where one party, whether it was by a consent final judgment or a final divorce decree, a typical provision would say that the wife shall be entitled to exclusive use and possession of the marital home. However, the wife shall be obligated to pay the entirety of the expenses associated with the marital home. So in short, you have one party or the other, it doesn't have to be the wife, of course, it could be the husband, that's awarded a piece of property, and typically that property is encumbered by a mortgage that is in both parties' names, so it's affecting both parties' credit. And in this type of market that we're in right now, where a lot of properties are upside down, where you're unable to refinance properties easily due to the changes in banking regulations and banking requirements in order to refinance a piece of property. Oftentimes you have a situation where one party keeps possession of a piece of real estate, resides there, the bank loan is in both parties' names, and one party is obligated to pay all of the debt associated with that property, while the other is out there living someplace else and relying upon the other party to be timely in their payments because it's affecting their credit, and relying upon that party to do what's right by the order. I have a situation that just happened a month ago where we had a hearing on that very same issue. We had one spouse or ex-spouse was obligated to continue to pay on a debt that was in both parties' names. It was for an investment piece of property, a lot. And the other spouse just decided in the middle of 2013 to stop paying that debt. And unfortunately it affected the other spouse's credit adversely, of course. And she had some debts out there with credit cards. Her credit card interest rates skyrocketed because of the other party's failure to pay that debt on time. She had credit that was reduced in her favor because of this bad credit impact that the other spouse had on her, and it caused a complete mess for her financially through no fault of her own. And the remedy in that situation is to file a motion for enforcement, and the motion for enforcement simply says that the other spouse was ordered to pay something, they didn't pay it, and it's causing financial harm and other harm to the other spouse. It's very tedious to seek damages for that type of situation, but the harm is real to the person who's adversely affected in the form of their credit due to the other spouse not paying what they're supposed to pay. What you should do if you're in that situation is file a motion for enforcement and try to calculate as best you can the impact that this has had on you. You want to file the motion for enforcement as quickly as possible. As soon as you find out that the other spouse is not doing something they were supposed to do, file it as quickly as possible and get a hearing in front of the judge as quickly as possible. In that situation, what you want to do is file a motion for enforcement that includes a request that the other spouse be obligated to reinstate the loan immediately to mitigate any damage it has on your credit. To that end, you should find out from the mortgage company what the reinstatement figures are. Since you're on the loan for that mortgage, contact the mortgage company and say, explain to the mortgage company, look, I'm in a post-dissolution of marriage matter. My former spouse was obligated to pay this debt. He or she hasn't done so. And I'm going to court on a motion for enforcement, and I'm going to try to ask the judge to force my former spouse to reinstate the loan. Can I have a reinstatement figure from you? And they'll readily provide that to you. The bank wants to get paid, and they'll cooperate in providing that to you. And by law, as you're a borrower on that loan, they're obligated to provide you with reinstatement figures, and bring those to court with you when you go to your motion for enforcement. Hopefully, if you catch this situation quickly enough, you're able to get into court quickly. The reinstatement figure is not so large that it's not able to be paid. And you want to go to court on that motion and try to demonstrate to the judge that your former spouse has the financial ability to pay that reinstatement figure. Of course, the former spouse is going to cry the blues and say they don't have any money to pay anything, but you want to be prepared for that hearing. You want to go into court with the reinstatement figures, and you want to be able to demonstrate to the court and ask questions of your former spouse, whether they have money in bank accounts, whether anybody owes them money, whether they have money anywhere else that they're able to pay this reinstatement figure with. Ideally, if you can get an order from the court compelling the other spouse to immediately bring that loan current, and they bring it current, you've mitigated your damage there as much as you can. Unfortunately, in situations like this, it's oftentimes difficult to prove that the other spouse has the financial ability to pay, because oftentimes they're hiding money. Oftentimes they're tired of paying money for debts that are common to both parties. Sometimes they're vengeful. Sometimes they're just, aggravated with the other party and want to hurt them as much as possible. And unfortunately, that's the way things go. And when that happens, you have a situation in this particular situation where one party's credit's being adversely affected by the other. The financial impact of that could be devastating. You could have, going back to the hypothetical situation, you could have one spouse who has 3 credit cards out there, who has perfect credit in the 700s, and the other spouse decides they're going to stop paying on a mortgage on an investment piece of property when they were ordered to pay it. All of a sudden, the interest rate on the credit cards go from 6% to 18%. Their credit is wound down. They're not allowed credit when they otherwise had credit. What you need to do in that situation is walk into court with your credit card statements and demonstrate to the judge, look, judge, before this all happened, here were my interest rates on these debts that I had, and after my former spouse stopped paying on this loan, here's what my interest rates went up to, here's what they are now, and be able to provide calculations to the judge as to how much impact this has had on you financially due to the adverse effects of what your former spouse did. And ask for that in the way of relief from the judge, financial relief from your former spouse. Even if your former spouse, let's say hypothetically, you're able to demonstrate to the judge that your interest rates have gone up over the past year by 12%, and that you've had to pay interest on your credit card debt equal to $2,000, $3,000, $4,000, $5,000 more than you otherwise would have paid. The judge in your divorce court has a right to enter a money judgment against your former spouse for whatever financial impact has occurred to you as a result of your former spouse not complying with the court's orders. So although it's tedious, although it's complicated, and nobody wants to sit around making calculations of how this type of act has impacted their lives, those efforts can be very fruitful in getting a judgment entered against your former spouse, a money judgment that's collectible for years to come. So If you don't feel like doing that, there's plenty of attorneys out there willing to do that. And like I said, if you go into court and you prevail on a motion for enforcement, the judges are inclined to award you attorney's fees and costs for having to do that. Because but for the other party's failure to comply with the order, you wouldn't have been required to hire an attorney in the first place. I spoke before the break about situations where you, again, hypothetically, you have two parties who have children, and they may agree at the final judgment that they're both going to share time sharing with the children. They're each going to get, 182, 183 days out of the year for overnight visits with the children, so that's equally split. Or you may have a situation where it's split 265 and 100, one spouse with the other, and child support is calculated based upon those anticipated time-sharing schedules. A lot of times what happens when parties divorce is that one party may not live up to that visitation schedule. You may have a lot of cancellations. You may have, unfortunately, ex-spouses that just disappear and visit a few times a year, maybe call a few times a year, but don't actually see the children. It's a sad state of affairs if that happens. And I get a lot of people who come in and say that, other than this basic child support amount I get, the other party has no involvement in the children's lives. What can I do about that? In that situation, you are entitled. You can't seek an enforcement because a judge can't force anybody to go visit with their kids, unfortunately. What you can do is you can file what's called a supplemental petition for modification of child support based upon that substantial change in circumstances. And basically what you do is file the supplemental petition. You go into the judge at a hearing and you say, Judge, my former spouse was, agreed to visit with the children, 100 days out of the year for overnights, or if it's a 50-50 split, 182 or 183 days out of the year, and now he's only visiting, or she's only visiting 10 days out of the year, not at all. If you prove that to the court, there will be a modification to your child support amount based upon that, and the court will calculate an appropriate child support amount based upon that time split. So for those of you out there who have a former spouse who's disappeared, who doesn't have involvement in a child or children's lives after divorce, you do have that remedy available to you of filing a supplemental petition to get relief from that. Getting back to motions for enforcement, in addition to former spouses who haven't paid, debt obligations that are impacting you financially in your credit, one thing you can also do is file motions for enforcement for any other thing that a person was ordered to do that they're not doing. Perhaps they're not paying alimony, not paying child support. I've had situations that happen a lot where the order said that both parties will alternate claiming the minor children for tax purposes each year, or that the one party would claim the minor children for tax purposes every year, and the other spouse who's not entitled to claim the children for that year, they run out when they first get their W-2 and they claim the child or the children before the other spouse has the opportunity to do it. That's a huge impact on you financially from a tax return basis, and you're not without remedy there. You can file a motion for enforcement and go into court and say, Judge, he or she wasn't allowed to claim the child or the children for the tax year, and they went ahead and did it anyway. And here's what's happened to me. If I would have been able to claim the child or the children, here's what I would have received in the tax refund. And because I didn't, this is what I received. And be able to demonstrate to the court the difference between those two numbers. And the court will not only enter an order allowing you to claim the children moving forward consistent with what your divorce decree was, the court will also give you a money judgment against the other party for the amount equal to where you would have been had you been allowed to claim the children for tax purposes. So it's complicated, it's a pain to do, but you're not without remedy to do that. And certainly if you hire an attorney in an enforcement action of that kind, you can also seek attorney's fees and costs from the other party, and the court will grant those award of attorney's fees and costs for you having to do that. There are situations of every kind with motions for enforcement. They deal with division of personal property. If, for instance, you were supposed to receive items of personal property and the divorce decree says you are to, and the other party doesn't cooperate in giving you those things, or if accounts were to be divided and the other party was ordered to sign off on allowing you to get that account, or they were ordered to sign a quitclaim deed for property over to you, or if they were required to do anything by the divorce decree that they're not doing, you can file a motion for enforcement to force and compel them to do those things. The court will actually order them to sign the documents, will actually order them to turn over the accounts, and if they absolutely refuse to do that, the court will order the third-party bank where the third party actually is going to administer that account to turn it over to you. So there are remedies available to you to force your former spouse to comply with every aspect of the order. So if you're frustrated out there and you're going through this process and you feel like the other side is just not cooperating with what the order required to do, and you're getting nowhere, you're getting stonewalled, just go ahead and file a motion for enforcement. It's a 2-page motion, and call it up for hearing and get in front of a judge and tell your judge what's going on, and get an order from that judge that assists you in the process. You're not without remedy. I want to talk for a few minutes about pickup orders. Pickup orders are orders that you can ask for the court to enter returning a minor child to the state of Florida in the event that the other party to your relationship has left the state with a child. So if you have a situation where you've been married and you have a child together, and perhaps you've separated and the other spouse decides they're going to move up to Minnesota because that's where his or her parents live, and they're going to go there because they have support there and a structure there, and you don't want that to happen, you can immediately file for divorce here in Florida because this is the place where you last resided as husband and wife. You should file in the county where your residence was as husband and wife, and if the other party refuses to return with the child, you can ask the court to enter what's called a pickup order. And a pickup order is an order simply stated that the judge orders all sheriffs of the state of Florida, and you can domesticate this order in a different state, of course, if they've moved out of state, to pick up the child and return the child to the county where the parties resided. There is relief for you out there. A lot of people get into situations where they get separated, and maybe at first they're agreeable to the other party moving into a house with family. Maybe it's out of state. Maybe it's across the state. I definitely discourage people from allowing that to go on too long. Agreements to anything, whether it be to a temporary residence or to child support amount or to an alimony amount, agreements like that can hurt you in a case moving forward. And if you're on the side of the agreement where you're benefiting from it, it'll help you. But if you're in a situation where you're just trying to diffuse a bad situation where there's been a breakup of a relationship of many years, and you're simply trying to bring some calm to the situation, and you say, well, I'll agree to give you, $2,000 a month in support, and you can go live in Pensacola with your mother. If you're making those types of deals, be very careful in doing that, because those things can come back to hurt you. What seems like a helpful hand where you're agreeing to provide some support may turn out to bite you in the end, because the longer that type of agreement goes on, if you're overpaying support, or if you're paying alimony or spousal support when you shouldn't be paying it, the fact that you've agreed to pay it and the fact that you continue to pay it month after month shows both that you have the ability to do that, and it shows also that the other party has the financial need for it. So before you agree to anything, even if it's just a situation where it's a month-to-month agreement, you've just been separated, and you both sit down and you come to some agreement about paying some spousal support temporarily or allowing one party to move across the state or out of state, before you agree to anything like that, get on the phone, talk to an attorney, schedule a consultation with an attorney. A situation like that, I don't charge for consultations of that kind of initial consultation. Pick up the phone, call me, talk to me about it before you enter into any type of agreement like that, because those types of agreements can come back to haunt you in a divorce proceeding. And a lot of people are trying to do the right thing. They're trying to make a bad situation tolerable, and they're trying to provide support in a situation where they're trying to make, they have the best of intentions. But unfortunately, and oftentimes this happens, the other spouse takes advantage of that generosity and turns it around and uses it in a contested proceeding that is to come. So be very careful when you go through those processes. If you do strike any type of deal with anybody on a temporary basis, and it's favorable to you, I always encourage people to put those in writing. Perhaps you send an email to the other party that says, you know, this is what we agreed to, something to document what's happened there, because you do want to make some record of what's going on, even if it's only on an informal and a temporary basis, so that you can use it later on if need be. As cooperative as people are going through these processes initially, things in family court tend to turn very quickly. You could have a situation where everything is as good as it can be in the situation. Everybody's getting along, everybody's in an agreement, and things could go on for, I've seen situations where people enter in a temporary agreement. One spouse says, well, why don't you give me $800 for child support? And the other spouse says, no, that's fine, I'll pay the $800 a month, and they're paying cash and or writing checks for $800, and there's no formality to anything. And that situation goes on for a month, and then it goes on for 3 months, then it goes on for 6 months, and then it goes on for a year, and something happens down the road. Perhaps you have a situation where one party starts a relationship with another person and they don't like that person, and things turn adversarial at some point. Things can turn on a dime in a family law situation. It's certainly something you want to protect yourself from moving forward. I have a lot of people come to see me and say that they've been separated for 2 years and the other party's been paying $800 a month in child support, and they have agreed to that. And when I run the calculations, the other party should have been paying $1,200 or $1,300 in child support. Vice versa, I've had situations where people have come into me and said, you know, I've been paying $800 a month in child support voluntarily, and it turns out they should be paying half of that amount based upon the income they're making. So again, get in and have an initial consultation with an attorney, start a relationship with an attorney, and get some advice that could save you thousands of dollars down the road, because it's well worth it to do that. Particularly in a situation where you're going to volunteer to pay child support. If you're out there and you don't have the money to pay for attorney's fees, go online, like I said, and find a calculative tool, a Florida Child Support Calculator, and punch in some very basic information about your net income and about the net income of the other party, whether there's daycare expense or health care expense, and come up with a genuine calculation of what your child support's supposed to be. You should always try to avoid just simply picking a number that sounds like it's something you can deal with and the other party sounds like something they'd want. Oftentimes you're making a huge mistake by doing that. In the situation I gave you previously, where the one spouse was accepting $800 when the other should have been paying $1,200, and it's 2 years down the road, there's no way to recoup those funds after the fact. So if you were to go and file in a contested matter and say, well, I didn't realize it, but my spouse was supposed to be paying $1,200 a month in child support and they were only paying $800, you're out of luck in that regard. It's your date of filing is the date that you can seek to have an enforcement of an amount that should be paid in child support. So go and confer with an attorney. My name is Sean Shepard. I'm an attorney for 18 years. I practice in the area of family law. I offer free consultations on all new matters. If you have a family law matter in the Tri-County area of Broward, Palm Beach, or Miami-Dade County, give me a call. My direct phone number is 954-632-0668. Again, I thank you for tuning in this week. We're here every week from 5 to 6 on Fridays, and thank you for tuning in. Have a great weekend.
Thanks for tuning in today to the South Florida Family Law Show with attorney Sean Shepard, with offices in Fort Lauderdale. If you would like to set up an appointment with attorney Sean Shepard, call his offices at 954-632-0668. And tune in again next week for another South Florida Family Law Show with attorney Sean Shepard. And let Sean answer your family law questions.